So thank you very much for putting this paper on the program. This is joint work with Anat Admati, who is joining us virtually from California at 1 a.m. I'm here physically, mentally, still a little bit 1 a.m. for me. So bear with us. This is very early work. This is the first time we've presented it. We're super excited to present it, get your feedback. Apologies to our discussant for our tardiness, but hopefully it can be a very lively discussion. So we're doing something very simple. We're asking this sort of simple but provocative question of which corporate victims get justice. Later? Okay. And really what we're going to do is we're going to take a simple idea, throw it out, collect some summary stats, talk about the data, and have a discussion around that. So I want to motivate what we're doing with this wonderful quote. What if Apple sold phones that it knew would explode after 1 year, and they all exploded and killed millions of people? And the Justice Department looked into it and examined the facts and the law and said, you know what? That's securities fraud. The real victims here are Apple's shareholders who had no warning that the phones would explode and kill their users who have lost money when the stock dropped. Now, if you were an alien trying to understand the US legal system from cases like this one, also opioid cases, climate change lawsuits, gun control, and so on, you might conclude that the purpose of the US justice system is to protect shareholders from losing money when the companies they own harm consumers. Okay, this is a quote from Matt Levine, who writes from Bloomberg. It's not a hypothetical. The fact pattern is basically what happened in the Theranos case, which you may be familiar with. Elizabeth Holmes created this fake medical device. People were actually using it. People found out, and she was found guilty for defrauding investors, not actually for harming the consumers who were using this medical device that didn't work. So back to the hypothetical, just to fix ideas. We're going to make a safe iPhone, or we're going to make an exploding iPhone. If you make the safe iPhone, it costs $100,000 of manager effort, but it doesn't explode. So no damage to consumers. If you make the exploding iPhone, it costs no effort to make. It causes $100 million damage to consumers. The consumers will sue and get that money from the shareholders. So the shareholders would like the safe iPhone. Socially, we would like the safe iPhone, but unless we incentivize the managers correctly, they're going to make the exploding iPhone. So managers make the exploding iPhone. What's our reaction? Corporate governance problem. Okay, so managers here have the wrong incentives vis-a-vis the shareholders. Corporate governance problem, so there's a corporate governance solution. We want to tie manager outcomes to shareholder outcomes. And we know how to do this. There's a bunch of carrots, a bunch of sticks, incentive pay, market for control, reputation, legal consequences, and so on. Huge, deep literature on this and how we should do this. Okay, and we know how to do this. What happens with governance? We align incentives, the managers make the safe iPhone. Shareholders, and importantly, this is what we're all after here, society is better off with better corporate governance. So I slipped in a key assumption here, okay? And that key assumption is that the consumers can sue the shareholders for $100 million. If they can't do that, the corporate governance solution breaks down. It doesn't work, okay? We're assuming that that right is well protected. If it's not well protected, the shareholders actually want the exploding iPhone, okay? So in order for this governance idea, shareholder value maximization idea to work, we have to make sure that these basic rights are protected. This is like a very fundamental governance problem. Shareholders' incentives may be misaligned with other stakeholders. Not everything is perfectly priced, or there are sort of externalities in this relationship. But to be fair, we have like solutions to this. There's sort of this ecosystem of things, indirect control via markets, legal-based solutions like torts and regulations. And what we're asking in this paper is, do these legal aspects of this relationship, the torts, the regulations, criminal law, and so on, do they work? Okay? So does the legal system act to protect other stakeholders, especially compared to shareholders? And by the way, we heard great papers, really excellent discussion yesterday about ESG. This is not an ESG point, okay? ESG is about hoping that the shareholders will want to be charitable to other people. This isn't about shareholder charity. This is about making sure that basic rights are protected in the law. So we're asking who gets this basic justice in the law. So what are we going to do? We're going to assemble data insofar as possible, and this is a big effort. We'll talk about exactly what we did here. I think a lot of the discussion will be around sort of how representative is the data that we have. It's going to be tracking what we'll call corporate harms. So think of like the BP oil spill. With each corporate harm, there's going to be a set of victims, shareholders, employees, customers. And then we're going to tie those harms to resultant outcomes in the legal system. Okay? Is there civil action? Are there criminal prosecutions? Does someone go to prison? And so on. Then we're going to ask, does the legal action happen less frequently for non-shareholder victims? Okay? That's the basically summary stat we're going to tell you. And then we'll ask, is the legal action less severe when non-shareholder victims are harmed? So is someone more likely to go to prison when it's shareholders or non-shareholders? Again, I want to caveat, this is not some super well-identified machine learning fancy thing. This is like we're collecting data, going to show you summary stats, and we're going to talk about it. The main finding here is that shareholders seem to be much better protected than other stakeholders. So this idea of like shareholder primacy, this Friedman idea, maximize shareholder value, other rights are taken care of, that's good for society, that's not quite operating in the system that we're in. Okay, so I don't want to get like too deep into the literature. A lot of people in this room have contributed sort of deeply on a lot of these topics. Elizabeth, what she talked about yesterday, Holger, our discussant. Sort of the thing I want you to keep in mind, a lot of this is thinking like really specifically or for like, let's look at a particular law and let's look at outcomes under the particular law. We are purposely trying to not do that. We want to take a 20,000-foot view and ask, do these rights that we think should be protected, is the legal system able to step in here? Okay, so, oops. What am I going to do? I'm going to talk about how we collected the data. Probably spend the most time on that. I'm going to do the question of when does the legal system act? So think of this as an extensive margin decision. When does the legal system take action? When does it not take action? I don't think I'll have time to get to number 3, which is sort of the intensive margin version of this. Condition on the legal system taking some action. How severe is it? How serious is it? Happy to talk about that in the discussion, but I don't think I'll get there. So with the data, we're going to do what we can do, and I'll tell you what data we have, what data is out there. I think it's helpful to frame this around like what the ideal data set would be. So what would we like? Well, we would like the universe of times when a corporation causes harm to someone. Okay? And then we'd like to know, in those harms, does the law compel the corporation to internalize the loss? And this could be through like any enforcement mechanism you have in mind, settlements, torts, class action, civil, criminal, regulatory action, like market-based actions. We'd like to collect all of that. And by the way, like when we're in fantasy land, it would be nice to have exogenous variation of who's the harm victim. Okay, not going to have it. A data set like that doesn't exist. Let me tell you what is out there. Typically, data sets that are about like legal enforcement are organized by law. Okay, so it's like, oh, there's a big data set at Stanford about FCPA. There's a big data set at Stanford about securities litigation. The problem with data sets like that for our analysis is 2 things. One, when you organize by law, you're sort of like conditioning on who the victim is. And what we actually want is like variation in victims. So that's not going to give us any identifying variation. The other problem is we're conditioning on something happening in the legal system. Okay, and we don't want to condition on something happening in the legal system. The question we're asking is, does something happen in the legal system? So that data set we'd like doesn't exist. We're going to build it ourselves. To help out with this, we had an army of RAs. They actually said they would join for this conference. They're Stanford undergrads on a Friday night. It's 1 a.m. Not sure they'll join us, but if you're there, thank you guys. You really helped out. So we're going to build it with their help. The main difficulties here are that corporate harms tend to be hidden or unreported. It's going to be really, really hard to observe this stuff. And probably more fundamentally, a lot of the resulting litigation or legal consequences are sealed. So like a lot of this just goes into arbitration. We're never, ever going to observe it. Okay? So that means what we're going to get is a selected sample with some measurement error in terms of outcomes. It's going to happen. There's nothing we can do about that. The key then is to think about how this selection is going to bias our results. And we'll have a lot of discussion around that. There's kind of 2 data sets, one for the extensive margin, one for the intensive margin. How am I doing on time?
You have 10 minutes left.
Okay. I'm only going to be able to talk about one of them. which is data we'll use to study the extensive margin of this. So we're going to build this based on media searches. It's kind of simple what we do. We go to the New York Times, we run sort of programmatic news searches for cases where companies are harming people, various types of stakeholders. So we'll run this between 2007 and 2014. It's going to be programmatic based on the victim and the harm type. So when we think of victims, you could expand this further. We're going to think of like 3 types of victims: shareholders, customers or employees, and the government. When we think of the government, we think of that as like the government as an institution, not the government as like representing the public. You could have added like a 4th victim type, which is the public who suffers from global warming, but we're not going to do that. In terms of harms, we're going to think of classifying them like death or injury, basically like physical harms or financial harms. In our sample, the shareholders are not going to get killed, but customers, employees might get killed or injured. The government, shareholders in the government might suffer some financial loss. Okay. So you run the search, you have a zillion articles. Most of them are about totally unrelated things. It's like, oh, like John, the employee of BP, was killed in a car accident. That's not what we're looking for. So we manually check to make sure the sort of harm is relevant to the type of harm we're looking for. John, the engineer on BP's oil well, was killed when the oil well exploded. That's the thing we're looking for. And we sort of know also, based on the violation type, what the relevant law is. And I'll say a little bit more about that. After all is said and done, we get almost 300 observations. So this is not a big data paper. This is a small data paper. It's better than a no data paper, so at least we have something. So a bunch of harms happen, say 300 harms. Then we're going to link these harms to legal outcomes. And this is a super time-consuming manual process. Basically, we look for the most all-comprehensive sources of potential legal outcomes. There's a bunch of data sources that do this. I sort of touched on them. They're a little bit organized by the type of law that's violated. We do this manual link. Additionally, we spend a ton of time just doing unstructured searches. So we go to Lexis, we look for everything in Lexis about this. We do unstructured searches in Google and find everything that we can possibly find about this in Google. It's actually kind of nice that we have a small n because we can spend a lot of time looking exhaustively. So we're going to try to be as comprehensive as possible, subject to caveats. We think we're going to do okay. If it's observable, we think we're going to find it. Again, there's a bunch of unobservable stuff. Okay, so the arbitration we're not going to see. We'll do some robustness checks around that, which I'll tell you in a second. Let me skip this. This is the other sort of data set. So if you're watching this, you have alarm bells going off in your head. All these issues here, the main 2 I would think of are selection and observability. So let me tell you how we're thinking about this. Obviously, we're only picking harms that are notable enough to show up in the New York Times. Okay, so big selection problem there. By the way, though, we write articles about the S&P 500 or the CompuStat universe of firms all the time. We do this truncation, and we just ignore all these small businesses. So we're looking where the light shines, fine. On the list of things for us to do are to expand this to local media and so on, but we're not there yet. What it means is we'll get larger or more severe harms than average. There's another sort of more subtle, I guess you can call it selection issue or joint causation issue, which is it might be in the news because of a legal action, or its being in the news might cause a legal action, it sheds light on the thing. That's right. So what that's going to do is sort of bias the whole level, bias the entire rate of legal action up. The question for, the problem for our inference then is going to be whether that differentially affects shareholder harms versus non-shareholder harms. Might get to it in the Q&A. I think we have reasons to think this is going to sort of bias us against finding an effect, but I can talk about why we think that. So that's selection. Observability. So problem might be that it's easier to observe legal actions that occur on behalf of shareholders than other people. That's going to sort of bias our estimate. And a version of that is that many of these non-shareholder harms just go through arbitration or settlement. So it's not that it's hard to observe. It's literally impossible to observe by design. Okay, so we think we do a good job of picking up things that are possibly observable. We're very exhaustive about this. The arbitration thing is tricky. The way we're going to think about that is use a shock to the necessity of going to arbitration. So in 2010, right in the middle of our sample, there was a Supreme Court case, Concepcion, which basically said mandatory arbitration is fine across the United States. That's going to make arbitration easier to do. If arbitration is making a big deal for our measurement, then you should see like changes in the effect size around that. And we're gonna check and we don't find that. So here are some summary stats. This is who's harmed and the type of harm. The type, again, this is the New York Times universe. This is not the unconditional universe of harms. So customers, sort of evenly split among financial injury and death. Employees, when employee harms show up in the news, they tend to be about injury or death, not financial stuff. You should think that in the background here, there's like constant wage theft going on that like just doesn't show up in the news. It's like never gets reported. We're just not gonna see it. Shareholders, obviously, this is financial. Government, this is financial. The government stuff, you should think about it, a combination of like off-label branding and like Medicaid fraud, basically, plus coming out of the financial crisis, the government ended up owning a lot of like mortgage assets that they then sued originators and servicers about. So legal outcomes, we look at sort of civil suits, criminal suits, and then from all of these, we separate like security-specific things. This is more of like a sanity check to make sure the harms we're classifying are classified in a coherent way. That's the data. So when does the legal system act? I guess I have like 3 minutes to talk about this. We're gonna run this regression, okay? It's a really, really simple regression. We're gonna ask, does some kind of litigation occur with a constant, and then whether a shareholder was harmed, whether the government was harmed, and then we'll throw in these harm type fixed effects. I'll tell you a little bit about what I mean by that and how to interpret that. So the basic question is litigation more likely when the shareholders or government is harmed? That will be these coefficients. Without the harm type fixed effect, this is like the unconditional question. Like, so someone's harmed, what happens? When you add these harm type fixed effects, think of this as like conditioning on the legal avenue that's available to you to pursue damages. You feel like you want to include that in the sense like, hey, we should realize that like the standards of proof are different for like corporate manslaughter than securities fraud. Sort of, yes. But on the other hand, that's like an endogenous control. Like the legal system has decided that the standards of proof are different and we should take that into account when thinking about who can recover. So this is more gonna be, I'm gonna do it. I think it's more useful to think about the interpretation of this. Is this caused by differences in enforcement or is this caused by like the law is different? So this graph is basically the results of the paper. We can look by outcomes, civil, criminal, securities. Other stakeholders basically consistently are much less likely to see any kind of resulting legal action arise out of this. Very, very consistently. We'll do this in a regression form, which I'll say very quickly. Just, is there any litigation and is it different by whether shareholders are harmed, government is harmed? So yes. So it's something like 35 percentage points more likely to get some kind of litigation arising out of shareholder harms than anyone else. The constant, you can take it seriously or not. This is like the average rate of litigation in the New York Times sample. Do you think that's representative or not? You can decide for yourself. It's probably way high. Okay. It's true across civil, criminal, and securities. Okay. Condition on the harm type, so like let's condition on the type of legal remedy that's available to you. A lot of these effects go away. So the interpretation there is the legal system has decided that it's easier to pursue securities litigation than it is to pursue litigation when like shareholders are harmed. The kind of funny exception to that is when the government's harmed, it's criminal. Okay, so if you like defraud the government versus if you defraud like a customer, that's probably civil for the customer, it's criminal for the government. This is this robustness around Concepcion. You throw in these interactions and your conclusions don't change. So let me summarize this. Litigation is much more likely when shareholders are harmed. It's mainly driven by differences in laws and not like by enforcement. So that's like adding the fixed effects versus not. The exception is harm versus government. This is robust to shocks around arbitration. So we're probably missing a whole bunch of stuff. But at least in our sample, it's not sort of biasing what we're seeing. And then it's robust to other specifications, which we didn't include, but like you can do these huge like joint-wise interactions between all the parties that are harmed. It's robust to that. Okay, let me skip by this part and just sort of get to the conclusion. I'll give you the upshot of this, is when you condition on there being some civil litigation, is there criminal, is someone personally gone after, does someone end up in prison? Upshot is the government is harsher when it's harmed. So, you know, when you wrong the government is more likely to send you to prison. it's also true for shareholders. So when shareholders are harmed, they're much more likely to have remedies against individuals, and that translates into much more likely to have individuals go to prison. So let me conclude there. Like, we really, really, really focus on this manager-shareholder conflict in corporate governance, and there's an important underlying assumption there that other rights are sort of well taken care of. Our paper is just challenging that assumption. Okay, so the US legal system responds much more aggressively when corporations harm shareholders than when they harm other stakeholders. This is summary stats. We're just turning on the light, but I think there's a lot of interesting research to do here. It's a core assumption of corporate law governance. Around this discussion of ESG, like, we view this as antecedent to ESG. So if, like, contracts and laws were properly protecting everyone but the shareholders, it's not clear we would need to rely on, like, shareholder charity to get this done. Okay, so before we even start talking about ESG, we have to make sure the basic stuff is working, and it maybe might not be. This is also consistent with this idea that's out there, like, managers are sort of the strongest party, owners are sort of weak, but on top of that, others are, like, even weaker, and sort of thinking about how much power owners have versus how much power other stakeholders have is important. Okay, so this is just scratching the surface, just turning on the light. But hopefully this gets you interested and suggests a sort of rich agenda for future research. So thank you very much.
Thank you so much, Greg, for the discussion. Holger?
So since Greg and Anat's paper is fresh off the press, I've made some last-minute adjustment to the to the slide. All right. But I can already start saying, thank you to the organizers for inviting me to comment on this very interesting paper, and to Anat and Greg. Where are you, Greg? There you are. Yes, for putting out this important topic for discussion. All right. So, quick summary of the paper. You've just heard it. It's an empirical paper. It looks at data on harms and on legal actions. It asks the question whether the harms lead to litigation, and ask the question whether the legal action, if there is legal action, leads to an outcome of a particular form. Is it a criminal action? Is there an individual defendant? Is there a prison sentence? Intensive, extensive margin. And the results are basically, very briefly, shareholders get redress, others don't. Shareholders get more redress. In a nutshell. Greg said it with more nuance, but that's sort of like the basic finding or the basic claim of the paper, and others are the government, consumers, so on and so on. And the government gets like a bit of a better deal, but the others, they get screwed. All right, that's an old theme. In 1974, Mark Galanter wrote this article, very famous, Why the Haves Come Out Ahead. Of course, Mark Galanter was not the last, and he wasn't the first. The law, in its majestic equality, forbids the rich as well as the poor to sleep under bridges, to beg in the streets, and to steal bread. Anatole, France, in 1894. We can go further back. The last one that I'm aware of is like 600 BC. I'm sure there was something like this before 600 BC. Laws are like cobwebs which entangle the weak, but through which the greater break uninjured. That's sort of the general theme, and if you detect some difference in nuance here with what with Greg and Anat are doing, that's intentional. I'll come back to that. Now, the interesting thing, of course, is in 2022, seeing this coming out of Stanford Graduate School of Business. I guess that's progress, okay? Yeah. All right, so here's the question of the paper: which corporate victims get justice? I'll have 4 comments. One on the conceptualization, what does this mean exactly? Second one on the operationalization, how do you measure that once you've defined it? The third, interpretation of the results that we have here now, what's the upshot? And then the fourth is the relevance of the question. And I don't want to dismiss the question that's being asked as unimportant, but is this the most pressing question that we should ask, taking into account how well we can answer it? All right, let me start with the first comment, conceptualization. Personally, I think this is the most important one. So, victims. Who are the victims? Well, victims, there has to be some sort of harm. That's the definition in the paper. Well, what's harm? Just to give you some examples of what you might think is harm, investors harmed in the 2008 meltdown, prisoners who are stuck in private prisons in the United States. Many prisons are private. all of us in climate change. These are all harms, and many people have argued that there should be legal redress for those things. Not in their sample, not even in the picture. Why is it not even in the picture? I mean, these are big ticket items, okay? This is like huge stuff. This is big, not in the sample, because in the paper, the data description is not, they're still working on this, but I think that working definition is only legally cognizable harm counts as harm. Now that already, if you go back to the Anatole France statement, about how the laws are written and what the laws catch, that already rules out most of the, where I would think the biggest action is, just as from the get-go. We're not even having that on the radar anymore. Also, inversely, this may now catch non-problems. If you have a stupid law, a silly rule that fortunately isn't enforced, well, in this data collection, it's a legally cognizable harm, but there's no action. That counts as a problem. And I'm going to have an example of that actually coming up later. And it may append the interpretation of the results. The theme, as I said, is like the weak, shareholders, they get redressed, the others don't. Well, actually, shareholders, corporate law around the world, especially in the United States, has completely abjured the enforcement of claims for mismanagement. There are no claims for mismanagement. That's the biggest harm for a shareholder. If the manager manages badly, absolutely zero legal action, zero. So, you might say from that, well, actually, shareholders get a bad deal. They get a raw deal. I think they get a good deal. I mean, we shouldn't have legal redress for that. I'll come back to this question. But anyway, that just tells you, once you define away that big area of potential harms, you already get very different answers from you otherwise get. All right, get justice. One of my colleagues just gave a speech how everybody loves justice, and who would ever say that they hate justice? I will, because it's a very amorphous term and it doesn't actually say anything. And the question is, what does that mean to get justice? Does it mean that the victims have to get compensated? Does it mean that the law has to create deterrence? Or does it mean that the law must enact retribution? Those are different things. They can coincide, but they don't need to. For example, if the government imposes a fine, but there's no damages for the victims, then we don't have compensation. We might have deterrence, but we definitely don't have compensation. We might have retribution, but to the extent that it doesn't work in deterrence, we only have retribution. And depending on what you care about, these are very different things. And they might be generated by very different actions. One very important point here, and I'm going to get back to that as well. When there is successful deterrence, then there is no harm. I would say that is the best possible type of justice. That's sort of like, that's the idea of what we should get. But that's not in the sample. Because no harm, not in the sample, you don't know. You never find out about this, the potential harm that could have happened if the legal system were not in the background deterring it. Not in the sample. If you wanted to do that, of course, you'd have to, really even more complicated. You have to be what's the potential harm that there could be, and how do you even think about it? I don't know. I'm just pointing out that, if you want to measure how well the legal system is functioning, I think that is the most important point. Which harms are being deterred now? Not showing up at all in this sort of data exercise. Corporate. Question was, which corporate victims get justice? Is it a victim of the corporation, whatever that exactly means, or of the manager? Who's in, who's outside, who can be victimized by the corporation and who can't be? Shareholders, are they part of the corporation? Anyway, so it's a bit amorphous. And I think, going to get back to that as well, that really, that really has different implications for what you want to be looking at. All right, that's the, whoops, that was one too far. Comment number 2. Operationalization. So let's imagine we have defined these clearly and we have set out what exactly we want to measure. I'm going to follow here what I think Anat and Greg are going for. So what are they doing? Victim harm. How do they define the victim or the harm that's being generated? Well, Greg explained that they have this New York Times search for company articles that mention a company in connection with certain keywords. I've put them again on the slide. Greg had them on his slide as well. And Honestly, I'm not quite sure what exactly this generates. At the minimum, I think it's a convenient sample with unknown properties. And we can have a long debate what sort of biases it generates. My personal sense is it is such a small subsample of the stuff that we care about, and it's so unclear how exactly these things show up in the articles that I'm not even quite sure how to think about biases. One very important point there is, what sort of things do newspapers even pay attention to? Going back to the conceptual point, stuff that isn't cognizable as a legal harm probably gets less attention, I'm not sure. Or if it does, then it's framed in different words and therefore it falls out of the purview of the article. Not sure. Justice. Now, Anat and Greg, they look at litigation filed, defendants named, prison sentences imposed. Now, notice that deterrence here is out of the picture, not in. One of the three possible meanings of justice. Deterrence is not there. Compensation, out of the picture. One of the three meanings out of the picture. The only thing that remains here is retribution. That's when you have a prison sentences. For the other things, being litigation filed, defendant name, like just to give you a sense, until recently, every single M&A transaction in the United States had a lawsuit filed with individual directors named as defendants. Is that justice? I'll get back to that question. I don't think so, but we'll get back to that. Corporate, I already mentioned, is undifferentiated where the shareholders are the victims or the beneficiaries, and I think in the presentation actually changed a bit from the paper, and I like that, what you did there. All right. What I've said so far sort of suggests that even thinking about what data we would want is very hard. And I honestly, I don't know how I would do it if I were to do this exercise. But I do want to give like a little bit of a reality check. If I even like test myself, like what do I think should be the rough outline, okay? And so the first thing I would put on the table is iPhones do not explode, usually, okay? Now, it's an important point. Look, I am not saying that there are no problems in the world, okay? There clearly are problems. There are even big problems. But if we want to get like, how do we approach it, I think it's important to realize that there's also a lot of things that are not problems, that don't happen, that could happen if we had a worse system, and so it's important to keep that in mind. iPhones do not generally explode. You mentioned that there's wage theft left and right. Well, most people get their wages most of the time, and so that sort of seems to be working. Existential liability is never imposed for shareholder harm. Never. I mean, maybe for individual defendants, we'll come back to that, but at the corporate level, it is only imposed for other harm. Think of the tobacco settlements, by the way, by far the largest civil actions ever filed. The Purdue Pharma case. Again, I want to emphasize, the Sacklers, the shareholders behind Purdue Pharma, they may be getting off way too easy. Not questioning that, but Purdue Pharma is out of business, or to the extent that they're still in business, they are now in government hands. So there was massive enforcement over the opioid stuff, not for the shareholders. The shareholders are, in this case, it's not a public company, it's a bit different. Massive liability with career-altering enforcement also tends to happen mostly for other harm. Think of the BP oil spill, $20 billion settlement, one of the largest ever. Volkswagen recently, Wells Fargo, Boeing. Now, all of these are public companies, also trigger securities class actions, and maybe they trigger derivative actions, but those are like an afterthought. They are relatively unimportant for the executives because they are generally covered by D&O insurance, and if they're even held liable, and they're usually for much smaller amounts. And Wells Fargo, Boeing, yes, there were these things, they happened, but like the real deal was the DOJ enforcement, the national NTSA enforcement, and so on. That's the real deal, and that's in the name of and for the benefit of other constituencies. All right. I really want to emphasize, I am not saying that we live in the best of all possible worlds. We clearly do not. And I have my own personal lists of things that I find abhorring. And What I do want to say is that to the extent we have really massive enforcement, it's for other constituencies and not for shareholders, just as a reality check. All right. Now, let's go back to the findings that we do have in the paper and ask, what are we to make of the two main findings in the paper? Let's start with the extensive margin, which one might summarize with the moniker from Matt Levine: everything is securities fraud. And I should just ask for a little time out here. I actually wonder why you wrote that first part of the paper. Matt Levine is always right. Since Matt Levine is always right, everything is securities fraud. Not every securities fraud is another fraud. It follows automatically that there has to be more securities fraud action than anything else. So the first point, extensive margin, more enforcement for shareholders, that's just given by the scholastic deduction that I've just performed with Matt Levine. Okay. When Matt Levine says this, he says this in part because of the absurdity that the SEC would be looking into a Brazilian mine disaster in the name of investor protection. And I think that is absurd indeed, but I think he says that also for other reasons. One of them is that actually, is this good for shareholders? Most people think that that's bad for shareholders. They shouldn't think it's bad because many of these securities class actions are nuisance suits, definitely most of them. The only question is whether there's a redeeming virtue, that sometimes there's a good one and that has some deterrence value, but for the most part, people think that this is actually pretty bad for shareholders. So it shouldn't count as a success. We shouldn't think that that's done really in the interest of shareholders. And it might actually be useful for other constituencies to the extent that this is piling on and it creates at least some deterrence. Okay, so Vale, the mining company in Brazil that I just mentioned, they paid, I think, $100 million in fines to the SEC. Now, it would be better if they paid $100 billion in fines to the Brazilian victims, but at least you get that, so that's already a starting point. And if one took the conclusion from your paper, let's cut down the enforcement on behalf of shareholders, I'm not sure. Shareholders might be happy and others might be unhappy. So like the exact opposite of what one, I think, would take from your paper. On the intensive margin, you find that shareholder harm leads to individual defendants, criminal prosecution, and prison time. And I already mentioned that these outcomes, I'm not sure that these are the real ones that signify justice, but I also want to point out that that difference might be, I'm sure, is explained to a considerable extent by the different nature of the injurious action. So the typical fraud action, the typical securities fraud action, especially the bad stuff, like the Enron style stuff, that is stuff that happens with the direct involvement of management. They know, they are the ones actually signing the stuff, which is why, for example, on the criminal side, a prosecutor has the ability to go after the individuals involved. If you have something like the Wells Fargo account scandal or Volkswagen, notoriously, the reason why there's no criminal enforcement against the top CEO, there was criminal enforcement. The lower level US boss is in prison in Florida, I think. At the highest level, you don't get it because the prosecutors can't necessarily prove that the top level people knew about it. That's just the nature of the action that's going on. It's not that the legal system wouldn't want to go after them. It's just, it's tough. Also, since you mentioned Elizabeth Holmes and Theranos, I think it is, look, I can't prove it, and the prosecutors, for obvious reasons, would never admit this, but it seems pretty obvious to me that some government suits are technically about shareholder harm are actually motivated by other harm. So I don't think Elizabeth Holmes would have been prosecuted if it had really just been an investor-founder matter. Prosecutors looked into this case because of the medical side. They couldn't nail her for the medical side for evidentiary reasons, and so they went after the securities fraud. It's like Al Capone was nailed for tax fraud. The prosecutors in Al Capone's case didn't care about the tax. They cared about the murders. They couldn't prove the murder, so they went after the tax. So Elizabeth Holmes, I think, is in the same spirit. Now, in an ideal system, we should be able to nail people for the right crimes. But, I don't think that this means that it's like, we're doing everything for shareholders, not for others. No, we just have fortuitously have this tool available, and we use it, hopefully, in the right kinds of cases. All right. Last point, relevance. Again, I don't want to say that the question you're asking is not a question that would be worth answering if one could answer it. But I also want to say that for me, that's not where I would start. I think that the principle is, one injustice is one too many. So why is there any need to compare? If you can actually identify an area of the law where you think that there's no enforcement, but there should be, well, let's write that. And coming from a law school, it's not that easy. It's not that easy. So I sort of claimed that people think that securities class actions are bad. Well, actually, there's a huge debate about this. It's really complicated to figure out, given all of the difficulties of proof, blah, 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 unintended consequences. Not so easy to figure out which remedy should be available. So the cost benefit, you often can point to a harm, but then the question is, can you actually realistically remedy this harm without having too many costs in doing that? Now, comparison is often useful in order to, looking at equal treatment, is an important tool to sniff out pretexts. Okay, somebody says, oh, we can't do this, and you say, well, but you're doing it there. If you can do it there, why are you not doing it here? Clearly your reason must be bogus. But that only works if you're comparing situations that are sort of similar enough that you can infer from it working in one place that it also should work in the other place. With this stuff, I don't think that's the case. Like the risk of unintended consequences is very different depending on the kind of actions you're prosecuting, the evidence that tends to be available in them and so on. So that's why, again, concluding thought, again, that I'm happy that you're putting this important topic on the table. I'm not sure that I would approach it from the angle that you're approaching it, but I'm doubled now. But thank you for broaching this topic. All right, thank you.
Okay, let me say a few words about that, and then I mostly want to spend time on questions. So thank you very much. This is going to be super helpful comments to frame what we do going forward. I think one injustice is too many, yes, but we live in a political economy of limited resources, and we have to make political choices. It's I want to right all the wrongs, but BlackRock is up here telling us that ESG is going to save people from dying, and maybe we should also think about where do we want to think about deploying resources on things like this. So I'm going to sort of go through the four things you said. One is the conceptualization. You're right, we want to include climate change. There's a bunch of things that are a little bit too vague in the sense that it's sort of hard to, what is the legally cognizable harm? Sure. So we're intentionally we're being a little bit conservative on the types of harms we're looking for. We're not looking for specifically for legally cognizable things. So that's actually not what we're doing. We're not going to be catching non-harms that are technically harms because the law said they're harms. We're looking for harms where somebody died, somebody lost money. We're not looking for law violations. Okay, so that's sort of not how the construction of the data set is working. We're being very unconditional about what law is out there, and we should spell that out much more clearly. There's a bunch of sort of specific things which I don't totally want to get into. I think operationalizing this, totally agree that this is just a start. It's really, really hard. This is a very, very difficult data exercise to do. We don't want to be deterred by the fact that it's very hard. Okay, so it's not going to be perfect. We think it's a super first order important question, and so we're going to do what we can do, and then exactly we can have discussions like this. You know what, I agree the sample is selected. Let's talk about how the selected sample is going to bias beta 1 in the regression. And we'll think about that a lot. I think nothing obvious comes to mind from the fact that, yeah, these are things that are in the New York Times. Is that going to mean that, and happy to talk about why they might be biased, but is that going to mean that our coefficient is biased when you start thinking about the universe of harms? Also, yes, you're right. We want to think about, what are all the invisible harms that got deterred that we didn't observe in there? Absolutely. We would love to do that. I have no idea how to approach that, so we're going to approach this however we can approach it. So we're going to we're going to do what we can here. let's see, a couple other things. This is an important clarification. I didn't do a good job of explaining this. Everything is securities fraud, yes. That's not what we think, that's not how we conceptualize a shareholder harm in our paper. So when we think about a harm to shareholders, we're thinking about a direct harm to shareholders. Like there was accounting fraud. They lied about what was in the books. We're not thinking of a shareholder harm as you heard the iPhone guys and like thereby hurting shareholders. Like that's not the kind of shareholder harm we have in mind. Again, we should be more careful about exactly what we mean by that. You know, I have a lot of other specific things, but I think I will turn it over to questions, and maybe these things will come up. And I'll put you on hold and then go. Please, yeah.
So, hi. Thank you for citing my book. So, first of all, I'm going to respond to you and also to Holger's comments. So, on conceptually, I just love this. I think it's perfectly reasonable to expand the conversation we have about, corporate governance from just directors, managers, and owners. And I think it's really interesting to step out and think about consumer victims. Secondly, the thing about Theranos, just to be clear, it wasn't just an evidentiary issue that I agree that the reason that the indictment happened has to do with people dying and so on, but in terms of not being able to, whatever it means to get justice for those harmed beyond shareholders, it wasn't simply evidentiary. It's actually there was actually a legal issue the federal court ruled on about the limitations of the 18 U.S.C. 1343 wire fraud statute, because you really need this money and property requirement. So you would think doctors who were harmed they were dismissed because they didn't actually lose money. Secondly, some of the people who got blood tests, if they didn't actually contribute to the blood test, right, they were kicked out. So there's actually some structural design problems with the statutes, which brings me to a paper I'm working on, which I'm so happy you're writing this because I can use this. I'm writing a paper about suggestions to expand the False Claims Act, and I know you talk about False Claims Act because currently under the False Claims Act, only when the government is harmed can it bring the litigation against government contractors. And if we expanded that to get, and there's the key TAM, right? If we expanded the key TAM standing to allow consumers to bring false claims cases against businesses, you could kind of do this arbitrage around the limitations of class action statutes and mandatory arbitration by using FCAs. But what I like that you said, which I didn't think about, was I wasn't thinking about sharing the bounty with other consumers. So that would be one way to deal with this. I'm very interested in the examples you give, and I think it's okay not to sort of boil the ocean. I think you can just sort of step outside and say, what are these? And I think it's perfectly fine also to do anecdotal stuff and even not doing as much of the sample you do and say, let's look at these examples. Let's look at Theranos. Let's look at Purdue Pharma and so on. Okay, thanks.
So Greg, now that you have told me more about how you select, I'm now wondering, how do you select? You said not everything is securities fraud. If there's just something happening, then then there's a securities action. You don't count that. But the securities class action after anything is not predicated on the initial harm. It's predicated on the failure to disclose in time whatever they should have disclosed. So that is a fraud. It's not just the other thing. Now, you might joke about it and say it's everything is secure, but technically it's not that. So if you don't count that, then I wonder how you distinguish. Similarly, if you tell me you're not limiting the legally cognizable harm, but for example, you are not counting the harm from climate change, you are not counting people who are in prison and private prisons, you're not counting all of the other things that you might count. Like, how do you then distinguish between what counts and what doesn't?
Mm-hmm. Yeah, so on the securities fraud thing, maybe it's just a definitional thing. We think of the harm as like the primary harm. So like, what is the underlying harm? If like, in addition to that, you think about the shareholders as being harmed as a result of their losing money, we don't think of that as the shareholder harm. That's a classification thing. Why do we not count climate change? It's a matter of being conservative. So we don't want to sort of like go out there and say like, oh, capitalism is harming everybody, and like that's a harm that's not. Like we want to be able to point to a specific person who got harmed, who got injured, who lost money. We don't want to say, oh, society writ large was harmed. We would like to do that, and I think conceptually we should be including those. Just as a matter of being conservative, we're not going to. Am I the... Sure.
You can take over if you want.
Yeah, just real quick, interesting presentation. I've got some comments that track a little bit on Holger's, but maybe let me see if I can push them a little bit more. So when my law students come into law school kvetching about whether justice was done in a particular circumstance, I often will ask them to, go through the same argument, but I want them to substitute the word awesomeness, right? Rather than pursuing justice, law should pursue awesomeness, and then they all turn out to disagree about what they mean by awesomeness. And so I kind of feel like I want a benchmark in the paper on what you mean by justice, how you measure it, and what your baseline is. And that's going to give me a little bit of a sense of the Goldilocksian point. Is there too much litigation, too little, or just right? So I don't have a sense of optimality here, and I'm not sure that, I think Holger mentioned this a little bit more is better. On the shareholder litigation point, I think this is really tricky. There are a lot of ways that shareholder litigation is a mechanical outgrowth of other forms of harms. So take a look at Boeing, which I think just ended up settling a $240 million derivative action that was caused because shareholders claimed correctly, at least if you believe their complaint, that because the board fell asleep at the wheel on safety issues, it caused the company to lose value and it caused them to lose money, and then they ended up settling. That was parasitic and therefore sort of almost mechanically multiplicative of the other issue. And in some ways, this is going to be a bigger and bigger problem for this project because that's one area. These oversight claims, sometimes people call them Caremark claims, are becoming a bigger piece of the landscape. So you're almost always going to get a double count. This is a version of everything is securities fraud, but everything else is a derivative action as well. So it's important to try to figure out how are we double counting? I mean, these are on some level the Captain Renault, the shareholders were kind of rooting for the board to cut corners as long as they never got caught. But as soon as the board gets something bad happens, the shareholders are shocked there is gambling going on in this casino. Last point, and I'm not sure, I didn't quite follow the identification strategy with Concepcion, but a couple things you might want to push a little bit further on that, data permitting. First, I think that you said 2010, but I think it was a 2011 case, not 2010. Okay. Two other things that might be interesting if you're into the triple diff kind of world. So Concepcion ends up being a consumer class action waiver in arbitration, so it's largely a consumer issue, and it only seems to have related, at least predominantly, to a precedent in California. So there's a jurisdictional heterogeneity that then gets closed up. You might be able to exploit. Yeah. And then 7 years later, I don't know how late your data set goes. That gets then applied in a labor case, in a case called Epic Systems. So you might be able to squeeze a little bit more out of your identification strategy.
Yeah.
Just before you answer, can we take one more question?
Sure. I'm going to forget these three. But yeah. Let me quickly. So on the Concepcion plan, yes, exactly. We actually spent a lot of time collecting these jurisdictional differences, and we're going to run that test to make sure. I would view that more as a placebo test on our data collection rather than an identification strategy. But yes. To clarify in the securities thing, the Boeing harm does not show up in our data set as a harm to shareholders. That shows up as a, I guess, consumer harm. And the first thing was, what is justice? In the paper, justice is, does someone pursue legal action? That's how we operationalize it. It's super unsatisfying. And the word justice is way more loaded than do we see litigation as a result of this? That's how we operationalize it. That's sort of the best we're going to do in measurement so far.
Just a couple of points. It seems like you're focusing on shareholders, but it seems like debt holders should also be considered. They can have bear a lot of harm. And if you think of corporate bankruptcies, it seems like there are a myriad of stakeholders in the corporation who are seriously harmed in many cases. And the other point I wanted to make is that there's also things like the gun industry has an exemption from being sued. And I suspect that there are some other industries that also have exemptions, which I think should be considered.
Yeah, great comment. I love the debt holder comment. We've sort of like, and there's like a lot of subtle versions of this, and we've thought a lot about how to do that. One is that like there's another paper to write about how, like, hey, why do the debt holders get paid before the tort victims in like the PG&E fire? Like, excellent. Like, do we think of like the buyer of a mortgage bond during the financial crisis as like a customer or like a debt holder? Like, I think that's sort of like part of what your question is. We've thought of them as like customers, although we don't have a ton of cases like that showing up, but like we sort of think of them as customers. Maybe we should think of them also as like investors, and we should be thinking of like the investor class versus the like consumer mom and pop sort of class. Like, I love that point, and we've sort of argued about this. Gun industry, like, we should talk more about the sort of like immune industries. That could be a really nice thing to think about.
Yeah, thank you. Thank you very much for the very interesting paper, because I think it sort of made us think a little bit, especially from a law side, and I think you're from the business side, right? So I think the definition of victim, you have to be very clear. Whether is it from a legal victim, for instance, like even a suit against by shareholders, we like derivative actions is actually a corporate harm. You know, it's just that shareholders gets a right to sue on behalf by the corporation against the board of directors. So we classify it as corporate harm, not shareholders harm. So I think in your definition of victim, you have to be very clear as to, are you using a legal term? Are you using a legal victim? Or are you using how you define a victim to be? I think from what you have described so far, it's a more general sense, right? Not so much of a legal sense. Like even for corporate actions, for shareholders' rights, there are only about 5 shareholders' rights that shareholders can have direct action against the board. For instance, you are not given right to attend a shareholders' meeting. Okay, that's a shareholders' harm. You know, so I think in definition of harm, you have to be very clear. So how do you define your scope? I think that will be, moving forward, I think it will be a bit clearer, you know. Yeah, thank you.
For us, a victim is the economic victim who loses money. We're purposely being very agnostic about the structure of the law. That's like the endogenous outcome that we want to study. So economic victim, who loses money, who's killed, who's hurt.
Any more questions?
Yeah, so I really like the paper. I wanted to build on a couple of comments about the overlap between security suits and other suits. And so it seems like in the analysis you're thinking of these as substitutes, so these are different types of victim that could be harmed, and you're looking to see whether they get justice. But actually, I think where people are pushing you is to see them as complements. And so if you were to restrict your analysis to non-shareholder constituencies, can you say something about which of those get piggyback security suits and which don't, and that gives you some sense as to like how much justice relative to each other they're getting. So that might be one extension you can do with your data. Another suggestion, and I'm sure, I'm hoping this is probably in the pipeline, is to look at the stock price impact of these the announcement effects of these different types of channels, and then see what's coming out there as well.
Yeah.
Can I add something to this?
Yeah.
I wanted to say something very similar on this. When Erik brought up the derivative suits for Boeing and so on, that most legal observers think that the reason why the Delaware court now allows these is not because they care about the shareholders. It's because they are doing some sort of like, judicial ESG.
Yeah.
They think that the courts should somehow do something against the directors if they are found to be asleep at the wheel, as Erik put it. And so even though formally this looks like, here the courts are intervening on behalf of shareholders, actually the motivation here seems to be, well, the government is not going after the directors individually. Let at least us, the corporate courts, go after them, so that in the future they won't create this sort of harm.
Yeah. So real quick on the stock price thing, great point. There's a whole other market-based way that you might think this is work, and we're not thinking about that, and that's the next paper or the next thing to think about. I don't want you to take away from this as us saying we should not have derivatives lawsuits. Very much they can be complements. We're not saying no, get rid of them. That's the argument. It's like bump up the other stuff. Like don't use this kludge, don't use this as a substitute, use them as complements. To be clear, in the analysis, we don't conceive of like something that results in a derivatives lawsuit as necessarily a shareholder harm. Again, we're like agnostic about the legal structure of how this works. It's like passengers in the Boeing plane died, what happens? Is there a lawsuit? We don't really exactly care about where that lawsuit is coming from.
So really like this project. It does seem very hard to do what you're doing, but I mean, I appreciate that, but it's like conceptualizing, I mean, if there's a way to automate this to a broader media sample, that would obviously be great, but it seems like very data intensive. As a separate project, what you could do is just focus on the intensive margin, right? So get the universe of cases that already exist in like the FCJ or Good Jobs First, and then have an analysis which is just conditional on a case being filed. What can we say about how justice is served within the legal system?
Yeah.
Which, again, I think that both projects are worth doing, but that might just be very much more tractable and like in a way that you guys could get a lot of leverage from. And two is, so piggybacking again on what everyone's saying, not only are there like tag-on security suits, for me, as somebody who thinks about securities cases and very much is always questioning whether or not they're worth it or not, I think the most valuable thing that securities cases provide is the information, right? Is the information that you get out of securities cases that could potentially lead to better cases, right? Because the unfortunate part is that it's hard to get into court. PSLRA makes it hard, but there's enough money behind these cases that frequently you get past the motion to dismiss, you get discovery, people figure things out. Maybe that's when the news figures out something happens that might be categorized in your data set as a harm. That's actually like a function of the security system.
Yeah, I love it. Like thinking of the securities lawsuits as a technology for moving forward this stuff. Totally agree. What we find in the paper is that technology that we have is not enough. So like, I totally agree, it's part of the equation. We don't want to get rid of it. Maybe it works, and like that's a really interesting like separate question to look at, like the complementarities of these things, but it doesn't seem like it's quite enough, which is like the first sort of thing we're after. The intensive margin thing, totally agree. I didn't really have time to talk about that, but we do sort of do an exercise like that. And the contours of that analysis are sort of similar, like treatment is harsher of you when you harm shareholders, more or less.
Okay, I think we'll have to end the discussion there, and thank you so much, Greg and Holger.
Thank you.